that I'm seeking to introduce through this witness. I've showed them to both of these counsels, and I showed them to the state. The state is objecting to one of them, and so I'd like to hash that out if we could at this time.
Okay.
May I approach?
Yes.
The basis of the objection, Judge, as you're looking at them, do you want to show them the other set as well? For the record.
Sure.
I'm agreeing to the first set, not the ones in your hands, Judge, but I'm agreeing to the first set. Ordinarily, and I told Mr. Kimmock this, I'm still in my case in chief. I'm not aware that defense can just enter evidence on my side of the case unless by agreement. The first set, I am willing and agreeing that can be entered because it came from evidence that I'm going to enter anyway in my case in chief, which is Michael Boatwright's phone. So that's why I don't have an issue as to that. The second set is not, and it's not necessarily something that I was going to enter. I believe it comes from either Facebook or Instagram page of the witness, and I explained that to Mr. Kimmock that I may not even enter that, so I'm not agreeing to the second set. I don't know if Your Honor has a preliminary ruling on that, but I'd also argue that it's not relevant at this juncture, the images in the second set, so I'm objecting to it.
All right, well, let me address it in a couple of ways first. Traditionally, state enters evidence on the state side of the case, defense enters evidence on the defense side of the case. However, it is sometimes my practice pursuant to 9612 to allow counsel from the other side, depending on whose case it's on, to go ahead and enter evidence through a witness that's now testifying. This doesn't matter, again, in the same rationale that we're trying three defendants together, a matter of judicial economy. This witness is here, it's on the stand now, to send him back and then to recall a witness solely for the purpose of identifying an item to come into evidence just seems to be a waste of judicial resources, and therefore will allow defendants to seek to introduce evidence on the state side of the case if, the witness is already there. So if that's the objection, it's overruled on that point. Now, relevancy and other things are other objections. So are you making an objection along those lines as well?
Yes, Your Honor.
Okay.
To the second set.
Understood.
To address your relevance, can we do that sidebar, please? I don't want,
I
the witness is on the stand at this point.
Okay. I'm on.
Prefer not to be huddled, if you don't have to be.
Judge, the photographs that we're seeking to introduce all come from Mr. Allen's Facebook account. They're all pursuant to the records posted by Mr. Allen. All of them contain Mr. Allen in the photographs with other men who match the description generally of the two men that we can see in the surveillance video at Riva. The last one in particular is a photograph of 4 men together that was taken less than a month before the shooting. And none of, obviously, neither Mr. Boatwright nor Mr. Newsom are in any of those photographs. That 4th photograph contains both Mr. Allen and Mr. Williams, along with 2 other individuals. It is part of our theory of defense that Mr. Allen is not only testifying to protect himself, but to protect the other 2 actual culprits, the actual murderers in the case. And so we are seeking to introduce these photographs to show the jury that not only were there other men in Mr. Allen's life who matched this description, but that who he was friendly with, that he hung out with, and that he hung out with Mr. Williams shortly prior, just prior to the homicide.
So this presents another problem. The other problem that it presents, Judge, is now if they're seeking to introduce photos, which is a portion of a complete set of social media, it's the same issue that Mr. Kimmock was addressing yesterday in terms of the rule of completeness. Also, in the second set of photographs, there are what the state would argue gang symbols that are being thrown up by one or more of the individuals, which then introduces potentially an issue that the state would have to rebut, which goes against, I believe, the 3 co-defendants. And it's more than just saying that these photographs, because for convenience, this particular witness can authenticate them. This witness is available and will be available throughout the duration of the trial.
I've already ruled on the order.
What I was going to say is because of the fact that this witness is available, the other issue is the authentication regarding where the photos come from, specifically Facebook. That is a separate authentication issue regarding the Facebook account. Same like the state would have to authenticate the Facebook through whether an affidavit or a records custodian. I believe this is an attempt to backdoor that in and to get in only a portion of evidence that might be favorable, I guess, to their defense. If that's their defense and they intend on making that their defense, they should put on a case if they're going to do that. So they're attempting to do that through the state's case, which that's the reason why I'm objecting as to that. And the other evidence I'm putting in anyway. So.
Judge, we would join in the request of Mr. Kimmock to have this admitted at this time. We feel it's directly relevant. And the witness himself can, of course, talk about authentication and give us everything we need. We don't need anyone from Facebook.
Correct. As to the authentication, this is the best person to do it. It's his Facebook account. He's the one who posted the pictures. He's the one who's actually in the pictures. As to the best evidence, all of the documents rule, I am more than happy to provide the entire report from Facebook. There is an extraordinary amount of prejudicial information about Mr. Allen that there's no possible way I could get that in. It has nothing to do with the homicide. And so if the state wants to do that, we're happy to do that, but there's just, it's his private Facebook account with all the messages and everything like that. It's just so, these photographs are relevant. They can be authenticated by this witness.
Right.
To be able to do so.
First of all, again, I've already made a ruling that I'm going to allow the introduction of evidence on the state side of the case. Yes, it's over the state's objection. Secondly, with respect to authentication of the photographs, the witness appears in each of the photographs, and it's similar to my ruling on evidence that the state was putting in. We certainly, don't have to know who took them, don't have to know that they come from Facebook, don't have to know anything else. It's just a photograph, and he can either identify them as being fair and accurate representations of what is depicted in the scene, or it's not.
Yeah.
So I don't have a difficulty with that. With respect to whether or not there are gang signs being flashed, we are not going to have anyone come in and testify about what are or aren't gang signs. And I suppose there are members of gangs who, if they saw signs, would recognize them as signs. Just as a person in the world, the court is aware that kids, adults, people who are not members of any groups or associations oftentimes make funny symbols with their hands. Sometimes they make symbols that are gang symbols, but that doesn't necessarily mean that they are members. So, unless counsel is intending to introduce them and say, so I see people are making hand gestures, what does that mean? That would be something different, okay? If it's a matter of, is this you, and do you know any of these people? I think that's fine. I would also say, though, that we are bordering the area of relevancy if we're trying to bring out how many people in Mr. Allen's life might be thin and between 6 foot and 6'2". That could be thousands of people. And I'm not going to allow the defense to bring in photos of thousands of people who may be of similar height and build, because I think that stretches the level of relevancy.
Yes, Judge.
But are there any other objections to these?
No, Your Honor.
Okay. Then over objection, if they can be authenticated, I will allow those in.
And Judge, we were just handed some photos by Mr. Padilla, so we just need to take a look at them before we address
Sure.
any potential objections.
Do the paper clip. I'm giving them back to you here pretty shortly.
I'm funny. That's really good.
Mr. Padilla.
Yes.
Every time you remove something, it's not the system itself, because I can turn the system off.
That makes it.
I can turn it on.
Okay.
That's why.
And I can, no, what? No, I'm not touching it. Some of the buttons.
I wanted to
I'm
look
working
at
on
it.
that. I wanted to see it working, because I can't, it's not like the whole screen is frozen, I can't hear anything. The unit? No. Whatever button that is not working. Something else you can pull up from somewhere.
Yeah, she needs to circle, unless you're gonna do it as a. Are there three pictures? If you did it as a composite, once it, everything is on the, so. So they don't get clear. But it's green. Yeah, no, I know.
I did unplug it and just plug it back in, so it's rebooting.
It's rebooted.
Yeah.
Oh.
This is what you said.
Are we back on the record?
If you'd like to be.
I'd like to be. There's just some additional photos that if we can address while we're,
Never.
on behalf of Mr. Williams.
Okay.
So there's 3 photos total, and they're close-ups of Mr. Allen. I recall the circumstances that Mr. Padilla took them under, and when he was deposing Mr. Allen, the questions about them were also regarding the gang affiliation of the specific images of the tattoos. I've asked Mr. Padilla about that. He says that's not the reason that he's going to be entering them. I would object if that is the reason, or if the line of questioning even comes close to that. He indicated that he's going to be asking for a completely different reason, and so I wanted to put that on the record in case it becomes an issue at a later time.
Judge, again, I will not be getting into gang affiliations.
So what is the purpose?
The purpose is, I'm gonna put him on the stand, and he's probably gonna say he's remorseful, and the bottom line is that he continues to break the rules. I have the image of him when he got arrested, and I have those images. That's one of the main reasons, and there's other reasons. Would you like for me to continue?
Yeah.
Okay, there's also the fact that he has a tattoo of a bag of money tattooed on his face, and in this case, he was charged with a homicide where they took a bag of money. So I believe it's relevant to say to a jury, he's remorseful. If he tells me, I've been remorseful since this happened. Really? Because when you go to Broward jail, you continuously get tattoos and things that could be construed as you're not remorseful and you keep breaking the law. So or the rules. I believe that it's relevant.
Regarding remorse, that's not, his feelings on what he did after the homicide or how he feels about it are actually not relevant. I didn't elicit any testimony regarding that. Also, anything that he's doing breaking the rules of Broward County policy and procedure while he's in custody are considered prior bad acts, which I don't know that the way that he wants to bring it out, I think we would have had to have a prior hearing regarding that to show some relevancy as to the crime at issue. And so I'm not sure, I would object based on that. And the jury can see, he's been here, this is going to be his 3rd day close to them in custody. He's not dressed up any different. They know he's in custody. They know he's pled guilty to murder, so.
Judge, I believe that depends on how he testifies. And I believe that it is relevant and I should be allowed to do that.
All right.
Hey, wait, what's up with you?
I just don't follow the argument that a tattoo of a bag of money means the person's not remorseful. I think that's a stretch. Secondly, the idea that he's breaking some infractions with respect to adding additional tattoos while in custody is such a collateral matter that would need testimony of people talking about what the rules and regulations are there and what exceptions there are, and they just puts us on a collateral issue that is not particularly relevant to the case. It would lead to mislead the jury and confuse the issues. And so if those are your reasons, your request to enter these are denied. Noted and preserved. If you would like, we can make those a court exhibit to attach for the appellate record.
Can I keep brainstorming and maybe address it later?
Certainly.
Judge, my final thing, at some point, I'm requesting permission to proffer a cross-examination of Mr. Allen about the alleged statements made by Mr. Newsome yesterday. That would include exactly where he was and all of that the court has said that we should not get into. And so at some point today, whether it's before or after, I'm requesting permission to do that.
This is outside the presence of the jury?
Yes.
Okay.
The court has ruled that we can't ask him any questions about it being in custody. And
Well,
circumstances.
He's
that
in
happen.
custody, but we're in custody. So
Right. I mean, that's part of our obvious theme of our cross-examination is that he is lying, is that he is continuing to lie. I think there's very serious holes in his story about what Mr. Newsom has said, and I'd like to be able to cross-examine him on that. The court has said no. I would like to proffer that.
Okay, you can proffer that, but also understand the rules of evidence when we're talking about, again, collateral matters. You are generally stuck with the answer you get, correct?
Yes, Judge.
All right. Would his having been spoken to for whatever reason by a defendant you are not representing be a collateral matter to you?
No, because Mr. Boatwright is sitting at the table with Mr. Newsom. His jury has been led to believe that it happened in the courtroom, and which would also tend to suggest there were other witnesses to it.
Which would be collateral evidence, which the court would not allow you to come in and bring extrinsic evidence of collateral matters to the trial.
I mean, I don't believe that there's any rule that would prohibit us from cross-examining him on something that he has lied about on the stand. And it is our position and belief that he was lying on the stand in a case in which Mr. Boatwright is a defendant.
Your position has to be based on something other than you think he's a liar. His testimony is consistent with that of the deputy who, when they were not together, gave an identical account of what occurred. You would certainly be free to ask him whether or not Mr. Boatwright was present at the time. It's clear that he was not. So, that's something that if you wish to ask him about, it's fine. But your internal belief that he's not being truthful with nothing else is not grounds for impeachment.
I'm confused because he's asking for impeachment, but this is outside the presence of the jury. So what is the purpose of trying to impeach him? And he asked him,
He
he
wants to
cross-examined
proffer
him
the
yesterday.
questions that he would ask if allowed to. That's what he wants to do. You can proffer the questions right now, even without him being here.
And also, Judge, he did that yesterday. So we're just going to readdress it again, even though the law of the case is that Your Honor has already ruled. He's not even bringing up a reason why he's challenging or has any redress with the court as to why he's allowed to bring it up again. Your Honor has ruled. He has remedies. He could file something with the 4th DCA. He could do that. I don't understand what we're doing here.
He only has remedies on appeal, not interlocutory for something like this. However, once again, you can impeach people with prior statements, prior acts, prior things that you have some independent way of verifying. You're saying, I think he's lying, is not, that's not a basis of impeachment. That's just your belief. You don't have a previous statement where he did not say that. You do not have a witness who was present at the time who would say that's not what happened. You just don't believe him. That's not a basis of impeachment.
Judge, I'm asking for a ruling on whether I can proffer that
You
testimony.
can proffer your question.
Can I proffer the testimony, please, of Mr. Allen?
His testimony is there. You can proffer your question.
So is the court denying my request?
Let's hear the questions.
The questions are, isn't it true, Mr. Allen, that this alleged incident did not occur in this courtroom, correct? Isn't it true that it occurred in a hallway in the jail, correct? And isn't it true that the person that said this was completely surrounded by curtains to the extent that you could not see the person inside, correct? Isn't it correct that the only way that you believe that it was Mr. Newsom is because you recognized his shoes, correct? And is it your testimony that you saw Mr. Newsom's shoes for all of 2 seconds when he walked into this courtroom yesterday? You remembered only, you remember not only his shoes, but whoever else's shoes are in this courtroom, and that's how you were able to identify that it was Mr. Newsom who allegedly said this to you. Is that correct?
Several of those questions are already in the record because you asked them at the time. And the first set of exactly where it happened, I've already ruled, is not going to come in front of the jury because it would prejudice one of the other defendants and really has no relevancy towards your client or your case. So your objection's noted, preserved. The questions you're going to ask are proper. Thank you.
On this particular issue, I have one more to mention.
Okay, well, I just, so we're clear? Anything
Yes,
else?
Judge.
All right, thank you.
So of the three, there's just one picture here, and this picture has the name Mercedes, and part of what I'm going to be getting, part of what I'm going to be getting into is infidelity, how infidelity prompted him to use other phones and do things to avoid the fact that he was being unfaithful. I believe that one of the people that he was being unfaithful with was Mercedes, and the fact that he tattooed her name on her forehead, on his forehead, is and for that I would ask just this one thing.
That'll be denied.
What just happened? Oh, he went to the restroom?
Yeah.
Oh, okay.
Did he?
Yeah, I didn't
We're
hear.
in session. We should not be leaving the courtroom.
I don't know.
Anyway, we can bring Mr. Allen back and while we're waiting for him to come up. Yeah, but it's not working. So I did unplug and reboot, and it's still not working.
Is someone coming down to work on it, maybe?
No, they're in probate.
How long is that gonna be? The roving thing?
I don't know.
All of them need to be there?
I don't know.
You got a lot there.
Judge Tudor's chambers, I can get you the number for them. You can call them up and ask them.
Sure. I'm just kidding.
So until that time, if we need to have a sidebar, the sidebar's going to be jurors going back
Okay.
until I can get this fixed.
Noted.
We had this issue happen once before in my courtroom, and they were able to, there's some
There's a
box
recess on
out in the
those.
hallway that they went and toggled something on, so once I can get one of the tech people here.
Want me to like YouTube some white noise and play?
Don't mess with me.
What I want you to do is stand there and go,
I got you.
and then we could do that, but no, maybe not.
Yeah, stop.
All right, parties are present. Are we ready to proceed?
Yes, Judge. Yes, Your Honor.
Okay, that's fine. And you're marking those as composites?
Yes, I
Okay.
haven't heard them, so.
All right, and,
Yes.
okay.
Yeah.
So you're calling Murphy too? So this would be like, no. He's like, how are we defendant vote right? How are we identifying it? How are you doing it? How are we gonna keep them separate? D1, D2, D3? I just want to be able to know what we're referring to as defendant vote right, exhibit 1, defendant vote right, exhibit 2, whatever. Okay. So we will identify them as defendant and then the names and then 1, 2, 3, 4. No, I mean, I did the same thing.
You did? Okay.
I just, when they get back there, they should be able to know, looking at the sticker, which one it belongs to.
DJ is a. I'm gonna get lowercase.
You know, they're home.
Someone's in the restaurant. I'm like, should I? No. You give me a hand signal. No. Yours, Ashley? Thank you.
Parties may be seated. Court will come to order. The parties are present. The jurors are present. Ladies and gentlemen, good afternoon and welcome back. I trust all of you were able to insulate yourselves.
Yes.
Very good. All right, thank you. When last we met, we were in the middle of the cross-examination of the witness by Mr. Boatwright's attorney. So first of all, you are the same Robert Allen that was here yesterday?
Yes.
I remind you, sir, you are still under oath. Counsel, you may proceed.
Thank you, Judge. Afternoon, sir. We left off yesterday where you had told the jury that you had changed your story between 2018 and 2022, correct?
Yes,
And you indicated that the story that you gave in 2018 was to protect yourself, correct?
yes,
Let's talk about others. You have other friends out in the community that were not any of the gentlemen sitting at this table, correct?
yes,
All right. You have your best friend is named Robert Morgan, correct?
yes,
All right. And he's someone that you still talk to on a regular basis in the jail now, correct?
yes,
You have another friend named May, correct?
Who?
Someone that you indicated named May.
sure I said May?
Pretty sure, yes.
I don't know, May.
Okay. You have other, you do have other friends in the community, though, correct?
Yes,
Commissioner, approach the witness, Judge.
You may. And also, Mr. Allen, it appears that that microphone may not be working right now, so I'm going to ask you to project as well as you can. Thank you. Counsel, proceed.
You had a Facebook account, correct?
yes,
Your name on that Facebook account was Robberly Rob, correct?
yes,
And you at times posted pictures of that Facebook account, correct?
yes,
I'm showing you what we've marked as Defense Exhibit A for identification purposes. I'm going to ask you to take a look at these photographs. There's 4 photographs. And once you've taken a look at them, you can let me know. Can I help him, Judge? Can I help him turn the pages?
Or you can lay them all out.
Do you recognize these photographs?
yes,
These are photographs that you posted to Facebook, correct?
yes,
All right. You are in all of these photographs, correct?
yes,
And these photographs all fairly and accurately reflect what was going on at the time that the photographs were taken, correct?
yes,
Defense would at this time seek to move Defense Exhibit A into evidence and publish to the jury.
No objection.
No objection, Judge, and we would move to adopt these photos on behalf of Mr. Musso.
Well, they're, all right,
Just for the record, I know,
but they're going to be identified as defendant vote right one, so
that's fine.
they're in evidence, and if you wish, you can ask the jurors to consider them on your case if you like.
Understood, thank you, Your Honor.
No objection.
All right, without objection, what was previously marked Defense Exhibit A for identification will be received into evidence as Defendant Vote Right Exhibit 1, a composite of 4, and you may publish at will.
Thank you, Judge. Thank you. So I'm showing you now what is 1 of 4 from defense 1. You recognize this photograph?
Yes.
Who are you in the photograph?
I have on a red sweater.
All right, you're on the far right.
Yes.
Am I correct that this photograph was posted on February 11th of 2018?
Yes.
And when it was posted with the title Family, correct?
Yes.
Who is this individual next to you?
Andrea.
I'm sorry?
Andrea.
Andrea? Andrea what?
I don't know that name.
Who is this individual here in the pink shirt in the middle?
Maul.
Maul. Can you tell us Maul's full name, please?
I don't know his woman.
Can you tell who this individual is here next to Maul?
James.
Can you tell us James's full name, please?
I don't know his woman.
Can you tell us who this individual is here in the black on the left hand side?
Hold on.
Can you tell us Polo's full name, please?
I don't know his name.
Showing you 2 of 4.
You can put it in the- Yeah, no problem.
You recognize this photograph. Which individual are you?
The one in all black.
Oh, cut off your head, I'm sorry. Speak up. And this was uploaded on February 25th, 2018, correct?
Yes.
The individual next to you, who is that?
Robert.
It's Robert Morgan.
Yes.
This is the individual who you have continued to have contact with. You call him regularly, even now, correct?
Yes.
Showing you 3 of 4. That's you on the left, correct?
Yes.
And this photograph was uploaded on April 21st of 2018, correct?
Yes.
Who is the individual next to you?
Nate.
What's Nate's last name?
I don't know.
And showing you 4 of 4. That's you on the right-hand side, correct?
Yes.
Who is this on the far left-hand side?
Diedrich Williams.
Same Diedrich Williams who's at trial here today, correct?
Yes.
The man in the middle with the ripped jeans here, what is his name?
James.
That's the same James from earlier, correct?
Yes.
And the man who is next to James,
I don't know.
you don't know him at all?
No.
Am I correct that both of these individuals are taller than Diedrich?
Yes.
And both of these individuals are taller than you?
Yes.
This photograph was uploaded on May 19th of 2018. Is that correct?
Yes.
less than a month before the shooting, correct?
Yes.
Okay. Who did you live with back in June of 2018?
My mom,
Who else?
my stepdad,
Who else?
Trayvon,
Okay. Who else?
sometimes Michael Boatwright.
Anybody else?
A lot of people come to stay tonight.
When you woke up on the morning of June 18th, 2018, who was at your house?
I don't remember.
Was your mom at your house?
I don't know if she was there when I woke up.
Was she there overnight?
Yes.
Was your stepdad there when you woke up in the morning?
I don't think so.
Was your stepdad there overnight?
Yes.
When you woke up, was Mr. Boatwright at your house?
I think so.
Okay. This is, you have been asked this question many, many times, is that correct?
Yes.
In 2018, you gave that statement first to Detective Curcio in October of 2018, and you were asked the question of whether Michael was there. You gave a different answer than you are giving now, correct?
Yes.
When you woke up, was Trayvon at your house?
Yes.
In 2018, when you gave this statement to Detective Curcio, and you were asked that question, did you tell Detective Curcio something else?
Judge, I'm going to object. This is improper impeachment. There are at least 5 or 4 statements, 3 of which are from 2018. And I believe he has to
October of 2018.
page line, please.
We're not there yet.
Well, I'm objecting to
Maybe we
improper
go sidebar.
Overruled.
Did you tell, in October of 2018, did you tell Detective Curcio something else?
Yes.
Were you lying in 2018, or are you lying to this jury now about whether Michael and Trayvon were at your house on June 18th, 2018, when you woke up?
So was I lying in 2018?
Were you lying in 2018, or are you lying to this jury now?
I was lying in 2018.
Isn't it true you can't get your story straight about whether Michael and Trayvon were there at your house when you woke up, because they weren't at your house when you woke up?
Objection argumentative.
Sustained.
Is there a reason why you would lie about something like that in 2018?
Yes.
What's the reason?
Because I was trying to minimize my involvement.
I understand that, and you have testified to that. How does saying that Michael and Trayvon weren't at your house when you woke up in 2018 minimize your involvement?
Because I believe I told Detective Curcio that they was already at Deidre Williams' house.
And that minimizes your involvement somehow.
Yes, because that would be me saying that I didn't know anything about any guns or anything like that.
Let's talk about this rental car. You testified on Wednesday that Diedrich specifically rented the car to rob people. Remember that?
Yes,
You're sure of that as you sit here right now?
yes,
There's no question in your mind about that.
yes,
Isn't it true that at the time Diedrich rented the car, you had no idea why Diedrich was renting the car?
you say, is it true that I didn't know?
Correct.
No, I was fully aware.
In your October of 2018 statement to Detective Curcio, did you say something different?
Yes,
You lied in 2018.
yes.
Judge, I'm gonna object. It's improper impeachment. May we go sidebars to this? It's, the way he's doing this improper.
Hold on.
impeachment.
All right, ladies and gentlemen, my sidebar thingy is not working, which is why the microphone system seems to not be working. I've asked someone from court system tech to come down and take a look at it, but until they do, and I don't have someone to stand by and go the whole time, so I'm gonna need you to step in the back when we have sidebar. Apologize about that. Thank you for your understanding.
If he's not properly doing it.
I don't understand the state's objection. The witness is saying something today that is different from what he said in October of 2018. I asked him, have you said something different in 2018? That is the next step. And up to this point, every time he said yes.
And he's admitted it. So if you're going to
All right.
impeach someone, he's admitted it.
But if he said
All right.
no,
Instead of you two arguing with each other, the court will make its ruling. I have some understanding of 608 and impeachment rules. You can ask a question. Did you make a statement at such and such time that was different? You don't have to ask the exact question. You can just ask the question, did you make a different statement at such and such time? The witness says no. Now we're going to say page, line, date, where, all that kind of stuff. and give them an opportunity to be refreshed if necessary, and then ask it again. When the witness says, yeah, I did give a different, the inquiry is done. And that's the procedure. And that's the way it's set out in the law. And that's the way we've been doing it for a long time. So up to this point, Mr. Kimmock's questions have been appropriate. He's asked him, did you make a different statement? And the witness himself has said, yeah, I lied at that time. So he's admitted to these inconsistencies. So if you were now to say, all right, let me pull them out and show them, no, that would be improper because he's made the admission. But the procedure at this point is correct. Your objection's overruled. Thank you, Judge. Anything further?
No.
Thank you. Bring them on.
Yes, sir.
All right.
Judge Onfroy?
Parties may be seated forward from the order. Parties present, welcome back. Counsel may proceed.
Thank you, Judge. You told this jury that you know that Diedrich rented the car to rob someone, correct?
Yes.
You weren't assuming, correct?
Yes.
You weren't guessing, correct?
Yes.
You know, correct?
Yes.
In July of 2022, so 8 months ago, when you gave a statement to this prosecutor, did you say something different?
I don't remember.
Excuse me?
I don't remember.
If I showed you a copy of your deposition, or excuse me, of that statement, a transcript of that statement, would that refresh your recollection?
Yes.
2022 statement, bottom of page 8, top of page 9. I'm sorry, I should have asked permission. May I approach the witness, Judge?
You may.
I'm going to ask you to start at line 19 and then go through line 5 of the next page.
Shit, tomorrow what?
Line 5. 6, yeah. You can read as much as you want. You got it?
Yeah.
That refresh your recollection as to whether you said something different about that in July of 2022.
Yes.
And did you, in fact, say something different in July of 2022?
Yes.
Something different than what you have told this jury about whether you knew that Diedrich rented that car to rob someone, correct?
I said I assume yes.
You said, I guess, and I assume,
Yes.
correct? Were you telling the truth to this jury?
Jay, you say I
Judge, I'm
was
going to ask him to speak up. I'm sorry, Judge.
when you testified about that, when the prosecutor was asking you questions, when you said you knew that that's why Diedrich rented the car, were you telling the truth to this jury?
Yes.
You told this jury that the whole plan that day was to ride around and rob people, correct?
Yes.
Back in October of 2018, to Detective Curcio, did you say something different?
I believe so.
Do you want to see the statement to refresh your recollection on that?
Yes.
Referring to the October 23rd, 2018 statement, page 61. If you could start at line 13, and you can read to the bottom.
Line 13.
Start at line 13, read to the bottom. Did Detective Curcio ask you if you knew what they were getting into that day?
Oh, okay, yeah.
Does this refresh your recollection about what you said back then?
Yes.
And with regards to whether there was some sort of plan to rob someone, did you say something different in October of 2018 than what you were telling this jury during this testimony?
Yes.
Actually, let me keep this for a second. And am I correct that during this conversation back in October of 2018, did you feel like you were being pressured by the police to say something that you didn't know?
No.
Back in 2018, did you say something different?
You're gonna have to be more specific.
No.
Sure. Back in October of 2018, did you tell the police that you felt like they were trying to pressure you to say something that wasn't true?
I don't remember.
If I showed you a copy of your statement, would that refresh your recollection?
Yes.
Bible on page 61, line 23. Back in October, does that refresh your recollection as to whether back in October of 2018, you felt like the police were trying to pressure you to say something that wasn't true?
Yeah.
Okay. Did you feel like the police were trying to pressure you to say something that wasn't true?
I really don't remember.
You remember saying it now. Is that correct?
Yes.
Again, after the October 2018 statement, you said there was no plan. State refused to make a deal with you, correct? They didn't make a deal with you in 2018, correct?
No.
They didn't make a deal with you in 2019, 2020, or 2021, correct?
Correct.
I don't know that I'm...
That's you. They're fixing the audio, but I'm telling this is probably not what we had in mind.
No.
Well, Mike got it. Mr. Allen, say something into the microphone.
Yes.
Yeah, no. All right, sorry. See,
Thank you, Judge. Between 2018 and 2022, your story changed about whether there was a plan to rob someone, correct?
Yes.
You told this jury yesterday that, it may have been the day before, that everybody left Diedrich's house with a gun, correct?
Yes.
You said all four of you had a gun, correct?
Yes.
And your testimony was that you were planning to do a robbery, and that's why everybody had a gun, correct?
Yes.
Back in 2018, when you were under oath, as you are now, did you say something different about that?
Yes.
The first time that you saw a gun, was it at the time that right at the moment that the robbery was about to take place?
Can you repeat that?
Sure. The very first time you saw a gun on June 18th, 2018, was it at the moment that the robbery was fixing to take place?
No.
Back in 2018, October of 2018, in the statement to Detective Curcio, did you say something different?
Yes.
When you were getting into the Dodge Journey at Chucky's house, so you're at Chucky's house, you are getting into the Dodge Journey, did you know there were guns in the car when you got into the Journey?
Yes.
Back in October of 2018, when you were talking to Detective Curcio, did you say something different?
Yes.
the rifle that was actually used in the shooting. Did you see that rifle prior to the robbery?
Yes.
Back in October of 2018, when you were speaking to Detective Curcio, did you say something different?
Yes.
You told this jury that you first saw the rifle come into the car with Michael, correct?
Yes.
Back in October of 2018, when you were under oath and speaking to Detective Curcio, did you say something different?
Yes.
You told this jury that you specifically saw Diedrich with a gun, correct?
Yes.
In fact, the prosecutor showed you an actual gun, and you said that was the gun that Diedrich had that day, correct?
Yes.
And you said that you saw Diedrich, you said to this jury that you saw Diedrich with that gun June 18, 2018, correct?
Yes.
Back in October of 2018, when you were speaking to Detective Curcio, did you say something different? I showed you a copy of that statement. Would that refresh your recollection?
Yes.
While you're doing that, let me pause you. I just want to try this. Seems to be working. Okay, thank you.
Page 21, the top of page 21. You know what, I need page 20. Sorry. So it's the bottom of page 20, line 24, to the top of page 21, line 7. Start there. So you told this jury that you saw Diedrich with a gun on June 18th, 2018. Back in October of 2018, when you were giving a statement to Detective Curcio, did you say something different?
Yes.
Let's go to July of 2022. When you were, well, you just told this jury that you knew that there were guns well before the robbery, correct?
Yes.
In the July 2022, when you were being interviewed by this prosecutor, just 8 months ago, did you say something different?
I'm not sure I remember.
I showed you a copy of that. Will that refresh your recollection?
Yes.
Page 9, line 21. Good look at page 9, line 21. Just read the question and answer. You told this jury that you knew that there were guns in that car long before the robbery started. In July of 2022, just 8 months ago when you were being interviewed by this prosecutor, did you say something different?
Yes.
On Tuesday night, when the prosecutor came to see you, did she talk to you about when you had first seen these guns?
No.
When you arrived at Riva and you were going to you're going into the store, who had the keys to the journey?
I don't remember.
Was the car turned on or was it left off?
I don't remember.
You going back to talking about the guns. You described in detail for this jury the guns that you say were there that day, correct?
Yes.
You said that Newsom had a .38, correct?
Yes.
You said that Michael had a GSK 22, correct?
Yes.
And you identified a gun that you said was Deidre's, correct?
Yes.
Back in October of 2018, when you were being interviewed by Detective Curcio, did you know the caliber of the guns that you say had been in the car with you? Curcio in October of 2018 about whether you knew anything about those guns?
Yes.
When asked what kind of gun Michael had in October of 2018, did you say something different than what you told this jury?
Yes.
When you were asked what caliber of weapon Trayvon had in October of 2018, did you say something different than what you have told this jury?
I don't remember.
If I showed you a copy of that statement, would that refresh your recollection?
Yes.
You look at, this isn't the right one. And your story has changed about the caliber of weapons that were involved in the robbery.
Yes.
You told this jury that when you were in Riva, you tried to call Michael, but it did not connect. Is that correct?
Yes.
Specifically with regards to whether it connected or not, whether you actually spoke to Michael. Back in October of 2018, when you were speaking to Detective Curcio, did you say something different?
Yes.
You said that you had spoken to Michael, correct?
Yes.
Going to 2022. All right, well, let's start here. At this trial, you have told this jury that the reason you called Michael was to confirm whether that it was X that was in the store, correct?
Yes.
In July of 2022, just 8 months ago, when this prosecutor was interviewing you, did you say something different about the reason that you called Michael?
I don't remember.
Did Diedrich ask you to call Michael to see if Michael needed anything in the store?
No.
Would it refresh your recollection as to whether you said anything different if I showed you a transcript of that statement?
Yes.
Page 10, line 11. Page 10, well, it actually kind of starts up at line 4, I guess. Line 4 down through line 13. Got it?
No.
All right. So you've told this jury that you called Michael to tell Michael what that X was in the car, correct?
Yes.
In July of 2022, did you say something different?
Yes.
That was just 8 months ago to this prosecutor, correct?
Yes.
Is there a reason your story has changed between July of 2022 and your testimony here today, the last 3 days?
Yes.
Isn't it true that that story keeps changing because you never called Michael on June 18, 2018?
I called him.
Let's talk about why this, what the plan was in when you were going to perpetuate this robbery. Was the plan to rob X of his jewelry, or was the plan to rob X of the bag?
The bag.
In October of 2018, let me back up. The plan was the plan specifically to avoid the jewelry?
Yes.
Why is that?
Because they had a crowd lock on me.
All right, and that was something that you discussed.
Yes.
Back in October of 2018, when asked what the plan was, what you were trying to take, did you say something different?
I believe so, yes.
Okay. You believe so or you know?
Can I see something? So we're friends with me?
Yes, absolutely. Page 24, line 10 through 14. Does that refresh your recollection about whether you said something different in October of 2018 about whether the plan was to rob Exodus jewelry?
Yes.
You've told this jury that the plan was to rob him of the bag, correct?
Yes.
In October of 2018, did you in fact say something different?
Yes.
You told this jury that on the way, that after the robbery, while you were driving south from Pompano, that Michael looked in the bag while you all were in the car, correct?
Yes.
In October of 2018, when asked whether anyone looked in the bag on your way down from Pompano, did you say something different?
Yes.
Is there a reason why your story changed between October of 2018 and now about why anybody looked in the bag?
Yes.
Let's talk a little bit more about the money. Judgment approach. Showing the witness is marked with defense B for identification. Ask you to look at these photographs. Tell me if you recognize them. Composite of 4 photographs. You recognize these photographs?
Yes.
Are you in all of these photographs?
Yes.
These photographs are taken after the robbery, correct?
Yes.
And they were in a hotel room up in, I think, Fort Pierce, is that correct?
Yes.
Do these photographs fairly and accurately reflect what everything looked like when the photographs were taken?
Yes.
Defense would seek to move defense B into evidence.
No objection.
No objection. Objection.
Without objection, what was previously marked defense exhibit B for identification shall be received into evidence as defendant boat rights exhibit 2, a composite of 4.
Permission to publish.
You may publish it, Will.
Showing you 1 of 4. Who are we looking at?
Me.
That is, what's in your hand?
Money.
Where did the money come from?
Robbery.
2 of 4. Whoops. Also you, correct?
Yes.
All right, taken same time, same place, correct?
Yes.
3 of 4, correct? That's still you, correct?
Yes.
Taken same time, is that correct?
Yes.
And 4 of 4. 4 of 4. Is that also you?
Yes.
Also flashing money from a robbery?
Yes.
In 1 of 4. 1 of 4, you are in a hotel room in Fort Pierce because you were fleeing from Broward County, correct?
Yes.
And Michael was there with you at that time, correct?
Yes.
Also, same hotel room, same time, correct?
Yes.
Michael was also there, correct?
Yes.
Same hotel room, same time, correct?
Yes,
Michael was there with you, correct?
yes,
You informed this jury during direct that you got $5,000, correct?
yes,
And you informed this jury that Michael got $15,000, correct?
yes,
You informed the jury that Trayvon got 15, correct?
yes,
You informed this jury that Diedrich got 15,000, correct?
yes,
Michael didn't get 17,000, correct?
no,
In July of 2022, when you were being interviewed by this prosecutor just 8 months ago and you were under oath, did you say something different about the amount that Michael received?
I don't remember.
If I showed you that statement, would it refresh your recollection?
Yes.
We're on page 23 of the 2022 statement, beginning on line 23 and going to the next page. Start right there. Got it?
Yeah.
All right. So I'll say it again. You told this jury that Michael got $15,000, correct?
Yes.
Did Michael get $17,000?
No.
In July of 2022, just 8 months ago, did you say something different?
Yes.
Is there a reason that your story has changed about how much money Michael got between July of 2022 and now?
Yes.
You told this jury that Trayvon got $15,000, correct?
Yes.
Did Trayvon get $12,000?
No.
In July of 2022, when this prosecutor was interviewing you and you were under oath, did you say something different than what you're telling this jury now?
Yes.
Is there a reason that your story would change about how much money Trayvon got between between July of 2022 and now?
Yes.
You told this jury that Diedrich got $15,000, correct?
Yes.
Did Diedrich get $12,000?
No.
In the July of 2022, when you were being interviewed by this prosecutor and you were under oath, did you say something different?
Yes.
Is there any reason at all why your story would change about how much money Diedrich got between July and now?
Yes.
Isn't it true that that reason is because Michael and Trayvon weren't included in the money cut? They didn't get any money.
Definitely got money.
It was other people, correct?
Other people, what are you saying?
Who got money?
No, Michael Boatwright and Trayvon Newsom got money.
Were you lying to the prosecutor in July of 2022 when you told them something different than what you told this jury today?
Yes.
Is there a reason that you lied to the prosecutor in July of 2022 about how much money people got?
Yes.
Did you lie, or is it you just can't keep your story straight?
Objection,
I'll withdraw.
argument.
I'll withdraw.
We will disregard the question.
When you got back to your house after Riva, who was there that lived at your house?
I don't remember.
Who was there at all when you got back to your house?
I don't remember.
Was there anybody there?
I don't remember.
You said on direct that, well, we go back to the house thing. It's your testimony that Michael and Trayvon came back to your house, correct?
They all three came back to my house.
After Riva, correct?
Yes.
Was there anybody else there who would have seen you?
Objection asked and answered, Your Honor.
I'll allow it, go ahead.
Can you repeat that?
Was there anybody else there at the house who would have seen them?
I don't remember.
You said on direct that Michael changed clothes after the homicide, correct?
Yes.
And you told this jury that he changed into his own clothes, correct?
Yes.
And you said that he did that because he had clothes at your house, correct?
Yes.
Did Michael didn't change into your brother's clothes?
No.
In October of 2018, when you were being interviewed by Detective Curcio, did you say something different?
Yes.
So which is it? Did Michael change into his own clothes, or did he change into your brother's clothes?
He changed his own clothes, but the hat was mine.
Is there a reason why your story would change about whose clothes Michael changed into between 2018 and now?
Yes.
Isn't it true that the reason you haven't been able to keep your story straight about what clothes Michael changed into is because Michael never changed into any clothes?
He changed.
I'm going to show you the part of what was introduced. This is States 3, was introduced yesterday. You see that? Does the picture come up in front of you there?
Yes.
These two people, who are these two people?
Michael Boatwright and Trayvon.
All right, and this is at 5:30 p.m. at the Driftwood Apartment Complex, correct?
Yes.
I'll play a little part, and then I'm going to ask you some questions about it. Michael's wearing shorts in this video, correct?
Yes.
He's wearing a T-shirt, correct?
Yes.
He's wearing a camouflage hat, correct?
Yes.
There are no guns on him, correct?
Yes.
He's not carrying any bag, correct?
Yes.
He's not carrying $15,000, correct?
I want to know if he's carrying $15,000.
Okay, so do you think that there's an ability for $15,000 to be carried in those, whatever he's got on?
Yes.
You would agree with me he's not running, correct?
Yes.
You would agree with me he doesn't appear to be in any hurry, correct?
Yes.
The prosecutor asked you on the first day if the gait and manner of Michael on this video were the same as the gait and manner of the shooter at Riva Motorsports. You remember that?
Yes.
And you said yes, correct? You agreed with the prosecutor about the gait of the Michael in this photo being the same as the gait of the shooter at Riva, correct?
No, I don't remember that.
not your testimony then that the gait and manner of this person is the same as the gait and manner of the shooter at Riva?
And you say gate and man, you saying the way they walk, right?
Yeah, that's it.
They don't walk, so.
Thank you. I'm gonna fast forward now to crash. Oh. Technology is a little slow. Because it looks like we're frozen. Do we have a brief comfort break anyways, or try to fix
What, technology issue?
It's
Certainly.
just frozen.
Let's take a 5-minute comfort break. Members will take it back there and let us know when you have an opportunity to use the restroom. The recess.
car accident, this is the Dodge Journey, correct?
Yes.
When you watch it, I'm gonna ask you a couple questions.
Mr. Kimok, if I could ask if you could just tell us the timestamp of where you're starting from, please.
We're at 13:20 right now.
Thank you.
Michael is nowhere in that video, correct?
Yes.
You told this jury that Michael was the one who was driving at the time of that crash, correct?
Yes.
Was Trayvon driving at the time of the crash?
No.
Back in October of 2018, when you were under oath and you were describing what happens to Detective Curcio, did you say something different?
Yes.
Were you lying about that in 2018?
Yes.
Is there a reason why your story would change about who was driving the car, Trayvon or Michael, between October of 2018 and today?
Yes.
Or a little more? I'm not going to fast forward it. I don't want to freeze it again. Let me go ahead about 2 minutes. This is a car, I'm sorry, I stopped it at 1620. This is the car that you ended up getting into, correct?
Yes.
Who was driving this car?
I don't think it would be appropriate to talk about who was driving that car.
Okay, so you don't think it would be appropriate to talk about who was driving the car?
Yes, as far as my safety, yes.
This is when you get into the car, correct?
Yes,
You're getting into the back seat of the car, correct?
yes.
What is this that you have in your hand?
Hat,
The camouflage hat, correct?
yes.
This incident that you say happened with Trayvon yesterday. Michael was nowhere to be found at that point, correct?
I didn't say no.
He was nowhere around, correct?
Yes,
None of the attorneys that are in this room were there, correct?
no,
The judge didn't see this happen, correct?
no,
You told this jury that you have not been promised anything for your testimony, correct?
yes,
You said the state, and the prosecutor asked you if they even hinted to you what it is that they're going to give you as a sentence, and you said no, correct?
yes,
You have talked to your attorney, correct?
yes,
And your attorney has talked to the prosecutor, correct?
yes,
Isn't it true that your attorney has repeatedly told you that you're going to get 5 to 6 years on this murder case?
that was possible.
That's what he keeps saying to you, correct?
Yes,
I can have 1 minute, Judge. I'm almost done, Mr. Allen. I want to give you one more opportunity to talk about whether you have been promised anything. We talked about the fact that the prosecutor has already changed the charge for you from murder in the first degree to murder in the second degree, correct?
yes.
Has the prosecutor given you any other benefit whatsoever already in exchange for you agreeing to testify?
I don't understand what you mean by benefits.
Has the prosecutor given you a benefit, given you something that is beneficial to you?
Giving me as of what? I don't understand what you're asking.
Has the prosecutor given you any plea deal as a benefit to you?
Open pleas, second degree murder. I don't understand what you're saying.
Okay. Has the prosecutor given you any plea deal to any other case?
What do you mean on any other case?
Sure. At the time that you were arrested on this case, you were on probation, correct?
Yes,
You were on probation for 12 separate felonies.
Judge, I'm going to object to this line of questioning, and I would like to take both sides.
that he stated?
Why don't we wait till that's on record? Okay. Thank you. Back on track. Back? Okay.
have been convicted of 12 separate crimes that are felonies or crimes of dishonesty. Is that correct?
Yes.
I will ask you again. Earlier, just in my cross-examination, you said that you did not lie to the prosecutor in July of 2022. Is that correct?
Yes.
And then later in my cross-examination, you indicated that you did lie to the prosecutor in July of 2022. Correct?
Yes.
Which is it?
I lied.
Nothing further. Thank you, Judge.
Cross-exam on behalf of the two.
Thank you, Judge.
So 12 separate felonies. You are really bad at committing crime. Can we agree with that on that?
Objection, Judge, argumentative and improper impeachment.
That's a question.
I'm objecting to the.
I'll withdraw, Judge. I'll withdraw the question.
The jury will disregard the questions and talk.
Let me get an exhibit here. There's, I need another exhibit. So I'm going to show you what was entered by the prosecution as, is it Exhibit 9, the gun. This particular gun,
Six, nine.
this particular gun that you testified to, you testified that this was Deidre Williams, my client's?
Yes.
Wasn't it your dad that got this gun for you guys?
Yes.
Yes, okay. And actually, your dad got all the weapons involved in this crime, correct?
No.
No?
No.
Which of the weapons in this particular case that you've alleged did not come from your father?
I don't remember anymore.
You don't remember which one, or you don't remember? What don't you remember? I'm sorry.
I don't remember all the guns they got.
So how could you know that they all didn't come from your dad?
That's my dad, and I don't know.
So when you say you don't know, you're just saying you don't know, but you don't really know which one came from your dad or not. We can agree on that? I'll withdraw the question, isn't it? Can we agree that your dad was a criminal?
Objection, Judge, relevance.
Sustained.
Was your dad in the business of not only selling guns, like you testified to, but of moving kilos of cocaine from Miami to Toronto? Isn't that true?
Judge, I'm going to object and ask for a sidebar.
Part that last question.
Sir, when was the first time that you met an individual by the name of Travis Savory? You remember meeting that individual?
No.
He actually goes by the name of Baka Not Nice. He's a Toronto rapper. Do you recall meeting him?
No.
Actually, isn't it true that that individual, Baka Not Nice, is the individual that allowed for you to gain access to the video shoot of God's Plan in February of 2018 that was shot here in Miami? Isn't that the way that you got on the set that day?
I never been on the set. No.
So your testimony to this court and to this jury is that you were never on the set of the God's Plan video filmed in Miami in 2018. Is that what you're saying?
Yes.
Okay. How much money in 2018 did you receive from either Drake or one of Drake's associates?
I never met him before.
You never met Drake.
No.
Do you know who he is, though, right?
Yes.
Okay. But actually, in 2018, when this crime occurred, you didn't know who X was?
No.
Okay, so in 2018, you're from Broward County, correct?
Yes.
You listen to rap music, correct?
Yes.
And you're telling this jury that you didn't know who literally probably the most famous rapper to ever come out of Broward County was in 2018, in June of 2018. That's your testimony?
Yes.
You had no idea who he was?
Objection asked and
Yeah, move on,
answered several
move on.
times.
Now, you testified that you got rid of a phone previously, correct?
Yes.
Okay. And that phone, you've never been able to find it, you've never been able to help law enforcement locate it, is that correct?
Yes.
Isn't it true that the reason that you don't want that phone found is because of all the WhatsApp messages between yourself, people in Toronto, people that are involved in this case that you want to shield from, correct?
I don't know the one in Toronto.
Actually, you actually want to shield people from this case, like you just did with the individual in that car that picked you up. Isn't that true?
It's the reason why I didn't identify her.
Okay. Do you think, as a cooperating witness, that you have the right to come in here in front of a jury in a murder case and refuse to answer a question?
Objection argumentative, Your Honor.
So you're testifying that that person has nothing to do with Toronto, the person that picked you up?
Judge, I'm going to object and ask for a sidebar with regard to this line of questioning.
You can't answer.
Repeat that.
Is it your testimony in front of this jury that the individual that you're refusing to identify that picked you up in that car has nothing to do with Toronto?
Yeah, she don't have anything to do with Toronto.
Okay. Now, actually, the individual that sold the guns that you testified to were involved in this crime, right? At least one of them, right?
Yes.
Okay, you're that,
Yes.
correct? Okay. And you can't sit here in front of the jury and tell us how many of the weapons that were used in this crime came from him. Is that your testimony?
Yes.
Could we say at least 4 of them? Is that safe?
No.
Less?
Yes.
Okay, so you tell me that. You obviously have some recollection of how many. So I would like to ask you, help me, how many were involved? How many came from your dad?
I don't know the exact number.
Okay, so, but you know it wasn't 4.
Yes.
Okay, how do you know it wasn't 4?
Because I know for sure Trayvon knew some gunmen come from him.
Okay, so 3?
I don't know.
Actually, the person that sold the weapons, a month after you finally cooperated in 2022, was murdered. Isn't that true?
Huh? What are you talking about?
Was your father murdered?
No.
Was your stepfather murdered?
No.
Okay. Now, you've actually given a version where you put my client as a person that's basically telling you what to do, correct?
Yeah.
But actually, in every single video and every single time that we see you, you're literally being chauffeured around by him. So I don't understand, like, how is it that you're saying that Mr. Williams, which basically looks like your chauffeur, is the one that's calling the shots? Is that what you're saying?
Objection, argumentative, and confusing and misleading question.
Overruled.
You can answer, sir.
I mean, I wouldn't say he's chauffeuring me around because it's actually his car.
Okay, but we'll get to that part because you're actually, the car that was used in this crime, you're the one that rented it, correct?
No.
You actually went physically to go get the car, correct?
Yes, I went with the person who went and got the car, yes.
Okay, so you actually physically went to go pick up the car, right?
Yes.
And you provided at least now with at least 3 of the weapons involved, correct?
What are you talking about? I don't get what you're saying.
The weapons that were taken, you brought them, right? Your father gave them to you and you brought them.
I never told you that.
Now, on the day that this occurred, when you went to Riva Sports, you testified that it was my client that noticed X. When in reality, wasn't it you the one that noticed him?
I can't notice him if I don't know him.
No, I understand what you're saying. I'm just saying that wasn't it you the one that pointed him out, and wasn't it you the one that said, hey, that's X? Correct?
I didn't know that.
You actually went into the store with your phone, right? And when you're in the phone, in Riva, you pick up the phone and you call people to alert him of exactly who's in Riva. Isn't that true?
Yes, I called Michael Boatwright to let him know that he was in there, but the call never went through. But also, Diedrich showed us a picture of him before we went inside the store.
Actually, you called your dad. Isn't that true?
Negative. No.
Who was it that arranged, when you fled the state of Florida, who was it that arranged that? That was your dad, correct?
Yes.
Okay. And he arranged that so that you could flee, right? Flee prosecution.
So he arranged it so I can get myself together to see what I wanted to do.
Get yourself together.
To see what I wanted to do because he's actually the person that wanted me to turn myself in.
Okay. And what's the purpose of leaving the state of Florida if you want to turn yourself in?
I didn't want to turn myself in, but he wanted me to turn myself in.
You didn't. You wanted to flee and escape justice, correct?
Yes.
Okay. Now, a lot of what you've testified to relies on your memory because you waited years and years and years pursuant to your testimony to finally come clean, correct?
Yes.
So this jury and all of us are relying on your memory. Can we agree on that?
Yes.
Okay. You're a drug addict. Isn't that true?
Judge, I'm gonna object relevance.
Judge, you
Also-
Sidebar?
Yeah. In 2018, you were in a relationship, correct?
Yes.
And what's the name of the person that you were in a relationship with?
Mercedes.
Mercedes, and that's the person that you have tattooed on your forehead?
Yes.
Okay, and in addition to the relationship that you had with Mercedes, you had relationship with multiple other women. Is that
Objection,
true?
relevance, Your Honor.
Sustained.
Judge, if I say,
Sustained.
okay. Were you also in a relationship with Miss Tony Robbins?
Objection, relevance.
Ooh.
You can answer.
No.
No. So you basically testified previously that you would call her every other day. Are you telling this jury that you would call her because it was a platonic relationship? You were friends? Is that what you're saying?
I don't know what the time means.
Okay. Are you saying that you were not in a sexual relationship and that when you would call her every other day, it was because you guys were friends?
No, I was calling her every day because we was renting cars to go rob people.
Were you doing that every day or every other day?
Every single day.
Okay, so your testimony now is that you were doing it every single day, correct?
Just about, yes.
Okay, and you're saying that every single day was through Tony, correct?
Yes.
Actually,
Through Tony, through Michael, through Dietrich Williams.
Actually, isn't the truth that Mercedes would look through your phone and you would take every opportunity that you could to use Dietrich Williams' phone to talk to her so that you wouldn't get in trouble? Isn't that true?
Objection, relevance.
Ooh.
You can answer.
No, it's not true because I had 4 cell phones that she didn't know about all of them. So I didn't need to use this phone.
Okay, I'm glad you mentioned that. You had 4 cell phones, right?
Yes.
What's the need for 4 cell phones? What type of activity are you in that you need 4 cell phones? Can you explain that to this jury?
I do fraud.
You do fraud.
Yes, I was doing fraud, yes.
Okay. And how do 4 cell phones help you do fraud? Please explain.
I mean, I need different phones to use.
No, I understand that you need different phones, but help me understand why you need 4 phones and how that can help you commit the crime of fraud.
For one, you change the IP address.
I'm sorry, I didn't hear you.
For one, to keep the IP address changed.
Okay, the IP address for what reason? The IP address for when you contact the person that you're defrauding, is that?
No, I'm not calling anyone to defraud them. I don't want them to know that I'm defrauding them.
Okay, so is it by the internet? Explain it to me. Explain it to me, like what is the IP address? How do you use that for fraud? And how did you use the phones for that?
Objection as to relevance and lateral matter.
Sustained.
So even though you had 4 phones, the day that this occurred, you're telling the jury that you only had 1?
Yes.
And how is that?
Objection argumentative.
You can answer. How is it that the day that you went to commit this crime is the day that you don't have your 4 phones, but you only have 1?
Because as you can see, I wasn't doing fraud anymore.
Okay, I'm sorry. You just testified that you were doing fraud, and now you're testifying that you weren't doing fraud. So which is it?
I wasn't doing fraud at the time because I was committing robberies.
Okay, so you switched. You switched career paths. You went from fraud to robbery. Is that what you're saying?
I was kind of back and forth.
You had your feet in both pools, right?
Yes.
Okay. So the day in June of 2018, on the day that this crime occurred, on that particular day, you had retired from fraud?
I wouldn't say that. I just didn't need the phone that day.
Okay. And the 1 phone that you had with you, that's the phone that you destroyed, correct?
Yes.
And you kind of touched on it in your prior testimony that you know that you didn't throw it away, right?
Yes.
But you can't remember what you did with it.
Yes.
Can you remember whether you destroyed the phone physically or you just tossed it?
No, I didn't destroy it. I don't remember destroying it.
You remember destroying it, but you can't recall what you actually did with it.
No.
Isn't it true that there's information and evidence on that phone that you do not want disclosed?
I mean, yes.
Right, and that's why you got rid of it, correct?
I didn't want to be attached to the phone number. That would seem to cause a microphone, right?
I'm sorry, I didn't hear what you said.
I I said I didn't want to be attached to the phone numbers that would see me calling Michael Boatwright while we were in the store.
Right, or anybody else that you may have called before or after, including your dad, your sister, and a bunch of other people, correct?
The reason I destroyed the phone was because I didn't want anyone to know that I was calling Michael Boatwright.
Okay, but you actually used that phone to call your dad and your sister and all those people after the crime, right?
I called my dad.
You called your dad actually the same day, correct?
Yes.
So let's talk about that. On the day that this occurred in June of 2018, when was the first time that you called your dad from that phone?
Can't remember that.
You actually called him while you were in Riva?
No.
Can you, when you say you can't remember at all, or was it an hour later?
It was after the murder.
Okay, then I understand that after the murder is a very broad term. I'm trying to limit it a little bit for the jury. Was it 4 hours? Was it 10 minutes?
Maybe about 4 hours, maybe. It was nighttime.
It was nighttime. Okay. But you for sure remember that you did not call him from when you were inside Riva and you first saw him.
Objection asked and answered.
Overruled.
You can answer.
I don't think I called him on the. No, I didn't call him on the.
Now, the phone that you have admitted that you got rid of and that you can't find anymore, is it your testimony that that is the phone that you had at Riva on the day that this occurred?
Yes.
Okay. And do you know whether or not you called your sister from that phone?
Yes.
Okay. And you took that phone up to Georgia?
No.
Okay. Where was it that you destroyed that phone or got rid of that phone? What state were you in?
Florida.
Florida. Were you at home?
I don't remember.
Okay. Do you recall the location that you were in when you got rid of the phone that you took to commit this murder?
No.
Now, you would agree with me that that is a fact that should ring in your memory. That's an important fact. Do you agree with me?
Objection argumentative.
Sustained.
So you're testifying in this case because you wanna save your own skin, or do you genuinely have remorse?
Objection not relevant.
Oh,
Which is it, sir?
Can you repeat that?
Are you testifying in this case because you want to save your own skin, or do you have genuine remorse?
Well, I definitely would like to get a lighter sentence, yes, but I definitely have remorse. I sit and look at the stand and see people crying, and I'm trying to do my best to get family, friends, and his fans justice.
Okay, so you have remorse today, now, when you see them, or you had remorse previously? When did this start?
I've been having probably about 5 months, 6 months.
5 months or 6 months, so really consistent when the time that you finally came forward, allegedly, and told the state attorney the truth? Is that what you're testifying to?
Objection argumentative.
I'll give you some latitude.
You can answer, sir.
Well, actually, I had a lot of time to think about it because I don't know if I should say it or not, but I'm on 23-hour lockdown, so I have a lot of time to think about it. I'm thinking about other people.
Okay.
Instead of being selfish, I want to think about myself and trying to just.
But you actually had years and years to think about that, and then coincidentally, you just started thinking about that when you finally cooperated with the state of Florida. Is that right?
I mean, I wouldn't say I didn't have no remorse at all, but by me sitting looking in the stands, I know I'm doing the right thing. There's a lot of people that was hurt by that.
But you're really sitting on the stand because you want to save your own skin and your own life. Is that correct?
Of course, I would like a lighter sentence, but I want to do the right thing.
Now, there was a picture that was entered into evidence of you on the day that you were arrested, your mugshot. Do you recall that?
Which mugshot?
Your mugshot.
Which one?
I mean, the one that they published to the jury. Here, okay.
I got arrested July 25th. I was in Dodge County.
Mhm.
I had a mugshot then.
Okay. I'm talking about the mugshot that was published of you that the jury saw.
Approach.
suspect, the people that actually assisted you in committing this crime?
That's the question you saying, is that what happened?
No, I'm asking you.
No.
Okay, I understand, I understand what you're saying. And then after this crime is committed, right? That's when you call your father and you tell him it's done. Is that what happened?
Objection, hearsay, improper, no basis, good faith basis for this question.
Counsel will refrain from trying to testify. Sustain. Jury will disregard.
Now, you've claimed previously and refused to testify regarding the identity of the person that picked you up after that accident. Now, just to be clear, my client wasn't part of that accident, correct? Deidre Williams was not in the car when that accident occurred, right?
No, he was not.
Okay. And your fear of that person, is that a fear that you're going to be killed?
You sure you want me to answer that question?
No, I'm just asking you, is the fear to the point that you want to be killed?
I don't think that question is appropriate for the jury to hear.
Okay, well, listen, you're the one that's sitting here refusing to answer questions in a murder trial in front of a jury. So are you under protective custody?
Yes, my status is protected custody.
Okay, so you're under protective custody, and even with that status, you're that fearful of this individual or the powers that be regarding that individual that you come here and refuse to testify.
Yes, they're gang members.
Judgment, either side.
Ladies and gentlemen of the jury, first of all, I want you to disregard the last question and answer. And if you recall, when we started, I told you from time to time, you might hear something that I will tell you to disregard. It requires some discipline, but it's something that people are able to do that where things should not play a role in your deliberations. I want to further make sure that you understand that regardless of whatever question or answer that I've told you to disregard, that there is no evidence before this court or this jury that either Mr. Boatwright or Mr. Newsom are in any way involved in any gangs or anything along that line. And you should not have any concerns in that area, and any kinds of thoughts along those lines or with respect to that should not play a role in your deliberations. It's not there. It's not there for your consideration. It's not there for you to think about. There's no evidence of that, and we don't want any questions that have been disallowed to in any way open up any lines of inquiry or thought that are just not there and not proper. Additionally, I want to remind you that, again, this is a joint trial. Although the three defendants are being tried together, they are three separate cases that are being considered at once. It is for the economy of not having to call each witness and go through this over and over again, but you are to consider the evidence that's adduced at trial as it relates to each individual individually, and your verdict as to one defendant should not affect your verdict as to another. Does everyone understand? Can you all follow that?
Yes.
All right, wonderful. Thank you. Counsel.
Judge, can I have a second on my phone?
Yes.
No further questions, Judge.
All right, thank you.
Can I have my evidence?
Oh, sorry.
Well, 5-5. All right. All right, so we are going to break for the weekend. As with each time we break, I will remind you, you're not to form any definite or fixed opinions, merits of the case till you hear all the evidence, arguments, counsel, instructions, and law by me. Until that time, you must not discuss this case, even among yourselves. During the course of the trial, the court will take regular recesses, during which you're permitted to separate to go about your personal affairs. During these recesses, you shall not discuss the case with anyone or permit anyone to say anything to you in your presence. Anyone does, remind them you're in the jury, ask them to stop, leave them, report the matter, you know the drill. If you see counsel, witnesses, defendants, anyone else associated with the case in the hallway, they will ignore you. They are not being rude. They are following the orders of the court. Please insulate yourself from any exposure to media, press, gossip, or other stories that may be out there. And with that, it's Friday. That's good. We got a couple days off. Monday morning, 10:30, in the reception area again. Hopefully all of you already have whatever letters and things that you need. Yes? If anyone needs anything further, again, don't hesitate to let one of my deputies know, and my judicial assistant will make that happen. I think that's all we need to go over with you folks. So again, have a great weekend, and we'll see you Monday morning at 10:30